My name is Doreen.
And I'm Nick Esterbauer.
Welcome to Hull on Estates. You're listening to episode number 609. Today we'll be discussing the Accelerating Access to Justice Act, but a very specific component of it, which has to do with the ability for the Superior Court of Justice to validate a will that may have been improperly signed under the Succession Law Reform Act. And I know, Nick, that this is something that you and Ian Hull have been working very tirelessly on. And if anything, you guys may have been, our harbingers of change. Do you want to describe that process?
Sure. Yeah. So Ian has recently been in quite a few discussions with the Attorney General's office. And just last week, there were public hearings before a standing committee on the Legislative Assembly on Bill 245. So there are a number of exciting developments we're seeing as part of that bill that deals specifically with estates. And I think maybe to start out, Doreen, it might make sense for us to take a look at just sort of what the deal is right now, what the state of the law is with respect to the validity of wills. So Ontario is one of the last jurisdictions in Canada to be a strict compliance jurisdiction. So here we've got requirements under the Succession Law Reform Act. And if we don't comply with all of those requirements, unless a court orders otherwise, you do not have a will.
Right. And, with those requirements, I think it might be a little bit rote at this point, but it really is that a will has to be in writing, where the will is not entirely in the handwriting of a testator. It has to be signed before two witnesses. And there is a very specific way of actually, the legislation sets it out. And in practice, you can actually see that a lot of things can go awry, even though the concept is, for the most part, straightforward, which is where you have a will that is in any way typed, the testator has to sign it at the very bottom before two witnesses, and then the witnesses have to sign their signatures to the will in front of the testator.
Right. And during the pandemic, we've seen that expanded just a little bit so that it allows the being in the presence of witnesses by way of audiovisual communication technology. So we've been seeing a lot of Zoom will executions, but people are still signing that document. You're still or separate counterparts of the same document.
And so because it requires three people to sign, more or less in succession, that's where sometimes, some of these mishaps may happen. It's just there's a lot of documents on the table. Sometimes you end up only having one witness signing the document, even though there were two other witnesses there. It just happens to miss a signature at the end of the day. And, if this bill does not come to pass and we do not have a validating provision that it's proposed in there, we're stuck with the standard status quo right now, which is that the Superior Court of Justice, at least in the way that our law has developed in Ontario, is that the courts do not really have a jurisdiction to make things okay, to make a will valid, despite those very strict compliance requirements under the Succession Law Reform Act.
Right. So we've seen a few sort of classic examples of where strict compliance will mean that a document that's clearly intended to be a will doesn't work. There's the example of a will that's not a holograph will, a typed will, where there's only one witness who signs it for one reason or another. We also just had a decision come out of the Ontario Superior Court of Justice re Swiddle Estate, where the witnesses were present not on Zoom, but on a phone call. So they signed the document and it was declared not to be a will because it wasn't compliant with the requirements under the SLRA and subject to the emergency orders in council that have sort of expanded the rules a little bit.
Right. So now, can you tell us about the proposed validity provision?
Of course. Yeah. So a lot of people are referring to this as substantial compliance compared to strict compliance. And it might function that way, but really what this provision says is that a court can validate a document. Section 21.1 of the Succession Law Reform Act, and I'll read it out just because I think the wording here is pretty important. So if the Ontario Superior Court of Justice is satisfied that a document or writing that was not properly executed or made under this act sets out testamentary intentions of the deceased or an intention of a deceased to revoke, alter, or revive the will of a deceased, the court may, on application, in order that the document or writing is as valid and fully effective as the will of the deceased, or as the revocation, alteration, or revival of the will of the deceased, as if it had been properly executed or made. This goes on with a subsection 2 that says subsection 1 is subject to section 31 of the Electronic Commerce Act, and subsection 3, which states that it applies only if the deceased died on or after the day that this part of the bill came into force. So that means in terms of timing, we don't know yet. And 2 appears to carve out any sort of electronic signatures.
Right. Yeah, we don't know yet if what is being proposed will ever come into law, but I think like that transition provision is also very important. It's just for litigators to know that you can't necessarily go back to your old files. I think we all remember these mishap files as being like great tragedies a lot of the times when it's just so clear that it was just like a slip of the pen, and like you said, it's just missing like say one signature, and the intention of this testator is just not going to be given effect. So we will continue to monitor this closely, but I want to go back to your point about how this is not a substantial compliance provision, because I think in case law that tends to be the distinction that is drawn between Ontario and other provinces who've had changes to their wills acts before ours have been done. And the word substantial compliance tends to be a part of those other statutes in other provinces. But here, really the court is just saying, as long as you can satisfy a judge that this is intended to be testamentary and it's a document or in writing, it can be given effect. So it's essentially saying it could be entirely non-compliant, other than that it be a document or in writing, as long as you satisfy a judge that it's testamentary. So this really just could have real widespread teeth. It just, there's so many different ways to satisfy a judge, especially, what if the sympathies are there, if it's unopposed in particular. Could be interesting one of these first cases if this ever comes to be.
Absolutely. It's exciting to have at least the potential for a new tool to allow the wishes of people who might not know how they're supposed to make a holograph will. And just honoring those wishes, the potential of it is something that to me is really interesting.
Right. But I mean, again, it's really too bad when accidents happen and formality should have been met before say an accident. But I do want to bring us back to why we have these requirements in the first place, is that the requirement to have 2 witnesses there if it's not entirely holograph will, it's just to actually lend reliability to the execution of the will. It's in that way you have hopefully 2 other people that will, again, hopefully survive the testator, who can speak to the reliability of this document. Because otherwise, again, as much as this could have a lot of teeth and be very helpful, without all of these hallmarks of reliability, then maybe what are we left with?
Mm-hmm.
Older people being abused, undue influence, fraud. I think at the end of the day, it might take quite a bit to convince a judge, even under this provision. But yeah, it's.
I think we should remember too that a court application that can become something that's quite costly, something that is time consuming. So this should not in any way be used as a reason to be any less careful. I know we won't be changing our practices when we're helping clients or advising clients on wills. We're going to be following all the same steps and procedures and taking them just as seriously.
bit of like a fail safe, I suppose. Just now that we may have something that could still help us out, but yes, not to be relied upon. That's for sure.
And I do find it interesting, Doreen. I'm not sure if you have thoughts on this as well, but just the fact that the proposed new section carves out electronic wills or documents that are signed electronically. This really does go back to the points you were saying about how there need to be safeguards in place to make sure these documents are valid. But with all the new technology we're seeing, maybe this is something that could change in the future. There are measures you can take. There's technology out there that can really verify that an electronic signature was made by the testator.
Well, it's still subject to change, I suppose. I think right now the legislature is still considering the bill, and we'll keep you posted on our blogs and our podcasts in the future. I think this concludes our podcast for today. Until next time, we want to thank you for listening. I'm Doreen So.
And I'm Nick Esterbauer.
Should you have any questions, please email us at webmaster@hollandhealth.com or leave a comment on our blog.